Hello students, we are starting with online teaching of Indian Penal Code being organized by Divine Institute. Today is just an introductory lecture and we'll be starting with first lecture from the date mentioned by the institute and the schedule mentioned by the institute accordingly. Before we start with that, I'll just introduce myself to all of you. I'm a product of Punjab University. From matric to BA, LLB, LLM, PhD. Then I joined as a teacher in the law department. I was shifted to 5-year law course as the first director of the institute, and I retired from there in 2007 with further extension of 3 years, thus practically leaving the institute in 2010. Thus, I have approximately 40 years of teaching Indian Penal Code in the department and also in various institutes. This is what my brief introduction is there. Before we start with that, I'll be talking to you from my personal experience, which I have seen, which I have observed as a paper setter also, as a teacher also, as an evaluator of judicial papers also. Certain things which are required to be taken care of for preparing any competition and more so for any judicial competition. I have minutely observed the result of PCS Judicial of 2019 and Haryana also of 2019. Certain things which have been made clear from the result of these two batches is that so far the law papers are concerned, students have scored very well. Thus, first indication that it gave that there is no substitute to hard work, because the competition is going to be very hot. Second thing which I have seen, that the marks scored by the students in the language paper, both in Hindi and Punjabi, are just near the passing marks. That is in case of Punjab, out of 150, most of the students have scored about 54, 55, 57, 58. There may be an exception of 1 or 2, but this is generally the score. That is barely minimum pass marks. Same is true to Haryana also. Their total marks are 100, and most of the students are scored just pass marks, even in that case with few exceptions. This is the first advice which I'll prefer to give to all of you, that do not ignore law papers, language papers. Reason being that it being your mother tongue, mostly you are overconfident. And I have seen, in spite of those preparations made by you, marks normally scored by you people are not very high. I just give an example. One of my students who is now already a judicial officer, he was so overconfident about the language that he has studied much literature, novels and all that, and he was a very bright student otherwise. He was there with me in the University Institute of Legal Studies. I had a confidence. I told him that if you score around 100 marks in Punjabi, you will be in the first 5 students in the selection list. When the result came, he was 9th. He got just 82 marks in Punjabi. I expected him to cross 100. Thus, though that doesn't matter, he got himself selected, but that pinch will be there when promotion will come. Then he'll feel the pinch. So this is what the first advice to all of you is there, that don't ignore the language paper. Look into the previous year papers of Punjabi and Hindi, because the syllabi prescribed for that is not specific. Questions are put from different areas. Sometimes quotations are there, sometimes idioms are there, sometimes gender number is there, sometimes this is there, even sometimes certain poetry couplets are there which you are required to explain. You have 4 or 5 year papers of last years. Look into that, the various areas which are covered in those papers, and accordingly prepare all those areas for your language competition. Because in a language paper, approximately 60% marks relate to grammar or similar kind of grammar related situations. There you can score up to 90%, even more than that also. So for essay part is concerned, which contain the maximum marks normally, you can never be sure how much marks ultimately you are going to get. The reason being, it depends upon the compatibility of your material with the philosophy of the examiner. If it is to his liking, you may get good marks. If it is not to that, then in that case, possibility of getting very less marks is there. Another thing, before you go for that, so for essay part is concerned, minutely examine the required essay, because sometimes students misunderstand what is required. Like one of my students came to me, he said that I have written an essay on national festival. I said, what you have written there? He said, I have written about Diwali function. I said, then you are going to get 0 marks. Diwali is not a national function. Thus, he scored very limited marks in that paper itself. Especially those questions which are quotation type, maybe Manjite, Jagjit, maybe any other kind of a quotation. In that case, firstly you must understand the meaning of that before you start answering that question. And throughout the whole of the essay, try to refer to that quotation, because that quotation is a kind of a sign of interrogation for you. You are either to prove that or disprove that. Thus, make a reference to the quotation wherever you want to find out and make a conclusion about any point in that essay. Normally, it must be around 5 pages. That also depends on the way you write. This is one thing which I prefer to advise for going ahead with this exercise. Now I just give an example. There are three categories of students who appear. One category which is microscopic in number, maybe 2, maybe 3, maybe 4, maybe 5, not much more. They are so bright that they are bound to be selected. So leave that category. Then comes the second category which consists of majority of the students. Immediately that follows that minority. If you calculate the marks scored by this category, second category, of only their law papers, the maximum difference between law marks, law paper marks, and those students who are not selected, immediately following 40-50 students. That difference may be 30 marks, 40 marks, 45 marks, not more than that. Thus, if you can make up 40 marks more in language paper, you can match up that difference which is there with regard to law papers. Thus, try to do certain things with regard to your language paper. 1. Daily write at least 2-3 pages of the language paper. Let somebody dictate you and you write. Then find out the mistakes which you have committed. Try to have that paragraph of that area from a newspaper, language newspaper, which is also relevant for your essay also. Like if there is some write-up on human rights, try to take up the paragraph out of that. If there is something related to environment, try to take up paragraph out of that. So that way you will be preparing for your essay also, and also you will be preparing for your language paper. This is very important. What I have seen, because this is the first advice normally I give to my students, but practically I have seen nobody bothers. They are so overconfident that this is their mother tongue, they daily speak that, there cannot be any difficulty. But look at the marks which have been scored by the students in 2019. We will find out the importance of this paper. This is one advice which I prefer to give to all the students, that always write at least 2-3 pages, let somebody dictate you, then try to find out your difficulties or your mistakes out of that and improve upon that. Second point which I prefer to give is, do not remain under the impression that the examiner will read your answer sheet. Nobody is going to read your answer sheet. Your answer sheet must speak to the examiner. So you are to write in such a manner that your answer becomes visible just by looking at the page itself. Examiner is able to find out, but you have written there. Thus, do not write like an essay. Make headings, subheadings, wherever required. You are not to be miser. So far the pages are concerned, there are sufficient pages for you. You can write the way you want. Thus, elaborate your answer in heading, subheadings, so that just by looking at the page, the examiner is able to answer or to know what you are writing in that. Since I have remained as an evaluator, I have seen that. Normally, not more than 5 to 10 minutes are taken by the examiner to look into your paper. and there he will try to find out whether the answer sheet is clearly speaking what you have written there or not. I normally narrate an incident that Hanumanji was told to bring Sanjeevani booty. He brought whole of the mountain and told that now you find out what is Sanjeevani. He can afford it, you can't afford it. You will have to bring Sanjeevani booty itself in answer to the question. Thus, this is the second point of advice which I will prefer to give, that write your answer in a manner that it becomes visible just by looking at the page itself to the examiner. Another aspect of that is, which I have seen most of the students give unnecessary material in answer to the question, especially if that question is thoroughly prepared by them. They are unable to resist themselves in writing unnecessary material. There, you waste your time and you lose marks. That goes negative. Because you are required to answer about 18 to 20 questions in every paper, law paper. You are tuned to answer 5 questions. So for LLB examinations are concerned, there you can get approximately 30-35 minutes for each answer. Here, in this case, you are to answer around 20 questions. And you are to accordingly plan, manage your time frame so that you are able to answer all parts of that. Thus, you are to manage your time for answering the question in a manner that you are able to answer all the questions. Normally, if the question is of 20 marks, answer must not be more than 3 pages. If the question is of 10 marks, answer must not go more than 2 pages. If the question is of 5 marks, answer must remain within 1 page. This is approximate. That is, it may be 1 page, certainly something more than that also, or it may be 2 pages or something more than 2 pages also. So that marginal exceeding the answer may be possible, but you can't unnecessarily expand it and thus waste your time. Thus, try to condense the material relating to the question in such a manner that you are able to answer the question within the specified limited pages. It also depends the manner of your writing also, because some people write in detail, some people leave margins, some people don't leave margins. So this is how you answer the question, but this is the time frame which you are to manage for answering these questions. Then comes time. For 3 pages, try to answer with less than 20 minutes. For 2 pages, try to answer with less than 10 minutes. For 1 page, try to answer within less than 5 pages. If you manage that, you will be able to have a comfortable zone which you can adjust if some question is lengthy, because by that process ultimately you will be having approximately half an hour extra, which you can accordingly distribute as per the requirement of the question. So this is the time management that is, because some of the students talk to me after the paper is over. Most of them, they say that they have left this question, they have left 5 marks, they have left 10 marks. This is the blunder. you commit. You are not, if you do not know the answer, then it is different. But if you know the answer but are unable to give the answer because of shortage of time, this is not condonable. You will have to pay the price for that in that case. Because sometimes you may be selected just by 1 mark. You may be luck just by 1 mark. So every mark counts in competition examination. Here, you are not to score the minimum. You are not to score 45%. You are to score more than the others. Thus, there is no limit. Here, the merit will terminate. You cannot assess. Efforts are to be made to score more than what the others have scored in order to go for the final goal, that is for interview. Another part of that which I will prefer to talk is regarding objective type question, which is the first hurdle which you are required to cross in order to appear for the main. I have seen some students are so bright that it will not be difficult for them to cross the main paper, but they fail in objective type preliminary area, thus are unable to compete for the competition. There cannot be any teaching of objective type questions. Certain things which you are to take care of that is number 1, look into all the illustrations of all the papers provided in the bare acts. Possibility is there that 1 or 2 questions may be there, or sometimes more than that may be there, only out of illustrations. So go through all the illustrations of penal code, CRPC, evidence, Hindu law, CPC, other areas. That will provide you some comfortable zone for the preliminary paper, objective type paper. Secondly, some of the definitions are such in nature that an objective type question can be put out of that. Thus, try to read all those sections which are relevant, out of which normally the questions are put, and objective type question can be possible. I just give 1 or 2 illustrations. Like, suppose the question is, which is the offence relating to property where no right of private defense can be claimed. Options are given like theft, extortion, robbery, dacoity. Most of the students refer to theft. It is extortion for which there is no right of private defense. Similarly, another example, that under sudden and grave provocation, person can cause the death of the person A, of the person who gave that provocation, B, any other person due to accident, C, any other person due to mistake, D, all the 3. The answer is all the 3. Thus, the definition itself has objective type questions. Similar such definitions may be there, where such objective type questions can be put. It may be relating to stolen property, that which out of the two or which out of the following is not a stolen property. cheating is there which doesn't make the property as stolen property. Criminal misappropriation, criminal breach of trust doesn't make it a stolen property. Sorry, criminal breach of trust and criminal misappropriation makes it a stolen property. Cheating doesn't make it a stolen property. Some other offences are there which also do not make it a stolen property. So similar such questions can be there which may be out of different definitions. So go through all the sections also from which normally subjective type questions are put in the examination, because some of them may contain even objective type questions also. So this is the second thing you are to do with regard to that. Thirdly, many guides are there which are having objective type questions. One thing is there that in some of the guides you will find wrong answers. So try to verify the answer. Don't purely depend upon what is provided in the guide. This has happened many times in various competitive examinations, in judicial papers. So try to, wherever you feel like some doubt, try to verify the answer from the Bare Act, from any other source which is available for verification. Purely depending upon the guide itself perhaps may not always be right. Third, another point which I'll prefer to talk about that is that if possible, try to have a small group, maybe of 2-3 persons, discuss with each other, not only objective type questions, but even descriptive questions also, because that will provide you good information and it will be easier for you to remember the answer when you appear for the examination. So that small group discussion is always important between you. Now, another aspect with regard to that is that there cannot be a classroom teaching so far objective type questions are there. You are to prepare all these questions of your own from these various sources which I have just talked. Another point with regard to competition examination where I have found mostly students commit mistake is relating to answer to the objective type, to the problem type questions. They are unable to find out how to answer that. Since, as I told earlier, that your answer sheet must speak to the examiner. So even in case of problem type questions also, your answer must be clearly visible just by looking at the page itself. Thus, whenever any objective type question is there, answer to that can be found out of two main sources. One, answer has to be found from the contents of the proposition. So go through the proposition itself at least twice, mark the points which are relevant for answer, which are supporting to your conclusion. Then you elaborate that by answering problem type questions. I just give an example. That was there in the judicial paper also. The question was that A and B both were security guards Both were having guns. On Diwali day, both wanted to go home earlier. That resulted into altercation between the two. Both pointed revolvers at each other. Then some other person came who pacified them. Both lowered their revolvers. When A saw that B had lowered his revolver, he took that opportunity and fired at B, resulting into death of B. A was prosecuted for murder. Trial court convicted him for murder. Case came to the High Court. High Court gave him the benefit of right of private defense. Then the question was, advise the government to file an appeal to the Supreme Court. This was the problem. Now this problem has two aspects. One relating to IPC, second relating to CRPC. When you are to file an appeal, you are to file as per provisions of Criminal Procedure Code. So answer both of them. Firstly, whether High Court was wrong in evaluating the evidence and thus giving the benefit of a right of private defense to A or not. Then reasons which support your conclusion. Firstly, you will give the conclusion that High Court is wrong in evaluating the facts and thus have wrongly given the benefit of right of private defense. This is the conclusion you have drawn. Then a reason to support that. Reasons are to be found from the contents of the proposition. Now, first point which you will refer to that is that as per section 100, to cause the death of a person, some assault must be attributed to the accused. That assault must cause reasonable apprehension of a danger of death or grievous hurt. Whether this requirement of section 100 is present in the given proposition or not. The answer is no. Reasons. Number one, once they were pacified by the third person, pacified means that they came to normal. Peace had come there. Thus, there is no question of assault. Second point, that once they have lowered their revolvers, that is the indication that normalcy has returned. Peace had returned between the two. Thus, that also negatives assault. Thus, there is no reasonable apprehension of any death or grievous hurt from the act of B. And accordingly, further, that A rather is acting in a treacherous manner, taking that an opportunity just to take the life of B. In view of the three arguments. One, pacification. Second, assault. Third, lowering the revolvers. Fourth, treacherous conduct on part of A. High Court appears to be wrong in evaluating the facts and giving the benefit of right of private defense to A. Then you come to the second part. Advise the government to file an appeal to the Supreme Court. Now, one indication that proposition is giving is that you are appearing from prosecution side. Since as per CRPC, if there is acquittal by the High Court, no appeal to the Supreme Court can be filed. Appeal is a statutory right. It has to be supported by specific provision of law, and that is not there in CRPC. Then how you will advise? Then you will say that government is advised to file special leave petition either to the High Court or to the Supreme Court to approach the Supreme Court in this case. in view of the facts given above, where High Court has wrongly evaluated the facts and has given the benefit of acquittal to the accused. So here you will advise the government to file special leave petition because appeal is not possible as per IPC. This is how you will arrange the answer. Take one more example before we go ahead. That was also in judicial papers. The question was, there was a team of doctors consisting of 5-7 persons. They removed the kidney of a patient, transplanted that into some other person. Then question was there. Discuss the liability of this team A for theft, B for robbery, C for dacoity. Now, answer to this problem is possible only if you are conceptually clear about the definition of theft, extortion, etc. Whether the components of that are present in the given situation or not. Mainly this proposition relates to whether there is a dishonest intention on the part of the team or not. Then you will answer separately for all these three questions, three parts: theft, liability for theft, then second liability for robbery, third liability for dacoity. Separately answer is to be given. So for the first part is concerned, you will say that 5 ingredients of theft are there, but in this proposition the relevant one is first ingredient only. First ingredient required, there must be dishonest intention on the part of the accused, and dishonestly is defined in section 24. First requirement of that is that there must be loss or gain of a property. Loss is there, gain is there, but does it relate to property? If you study, if you know the meaning of dishonestly, only then you will be able to answer this proposition. Property is not defined anywhere in the code. Movable property is defined. Property as such is not. So property means anything having proprietary value in the eye of law. Kidney has no proprietary value. Any part of the human body has no proprietary value. Human body has no proprietary value. Thus, there is no dishonest intention because the property here is not as per the definition of section 24, because kidney is not a property as it doesn't have proprietary value. It can be donated, and that to the rigorous conditions. Property doesn't mean that you can sell and make money. That will not make it a property. People sell human beings also, people sell children also, people sell women also, but that will not make them property. Property means, as per section 24, anything having proprietary value in the eye of law. Since it doesn't have a proprietary value, and accordingly, its first ingredient of dishonestly is not there, thus it cannot be a theft. Second, does it amount to robbery? Then you say that robbery is of two types. One, theft amounting to robbery. Second, extortion amounting to robbery. Since it is not a theft, there is no question of it being a robbery. Second is extortion amounting to robbery. Extortion also requires dishonest intention. But that aspect is not there even in case of extortion also. Secondly, extortion further requires a delivery of property, handing over of the property. That also is not there. Thus, it is not extortion. Third is, does it amount to dacoity? Dacoity is an aggravated form of robbery. Since there is no robbery, there cannot be adequate. This is how you answer. So one point which I'll prefer to clarify here is that certain answers you can give only if you are conceptually clear about the different aspects, different terms, different definitions given in the penal code. If you are not aware of that, then you will not be able to give the answer to that. Thus, one of the very important part of competition is having complete knowledge of various concepts. But I have found is that chapter 2, second chapter of IPC, normally you people ignore that because there is no question from that area. Only section 34 is prepared, from which normally the question is put. So for other aspects are concerned, dishonestly, fraudulently, knowingly, good faith, reason to believe, all other definitions you do not go to. So unless you are not aware of the exact meaning of these concepts, you will not be able to answer any proposition, any problem type question, which may be answered only in reference to that concept itself. So you are to thoroughly prepare chapter 2, various aspects of that. Now that we will be dealing when we will be starting with the first lecture. There, that may take approximately 4 or 5 lectures. That will be there when the regular online teaching will start from 1st of June. Then we will be starting with the first topic, where this area shall be thoroughly discussed. And that will be relevant not only to answer descriptive questions, but also to answer problem type questions. Another aspect with regard to proposition type question, problem type question is whether it relates to Hindu law, whether it relates to IPC, whether it relates to any other area, that you are to find out the relevant point, discuss that relevant point, give answer to that, and then accordingly make a conclusion. Just an example, though it is not related to IPC, suppose the propositions are relating to divorce, whether the person is entitled to divorce or not. Now, in answer to that, firstly, this is what I have told earlier also, that your answer sheet must speak to the examiner what is written in that. So here also, you will start with the answer that as per the requirement of this proposition, the person is entitled to divorce, is not entitled to divorce. Then second part, that this proposition relates to divorce, which is provided in this and this section. There are various grounds, but here the relevant ground is cruelty. Then you will confine only to cruelty. Discuss what requires cruelty. Then you will come to the contents of the proposition, whether cruelty is fulfilled, whether those requirements of cruelty are present in the given proposition or not. Then final conclusion, again you are to repeat the first part, that in view of the discussion, in view of the reasons given here, the person can claim, cannot claim. This, and if the proposition is based on some case law, then in that case make a reference of case law in the contents of the paragraph where you are discussing the various reasons relating to that problem type questions. This is the second part relating to problem type questions. Now, one thing which I'll prefer to make in the ending part also is that if any query is there, if any doubt is there, if any difficulty is there to any of the students, you may communicate that to the institute, you may communicate that to me through WhatsApp also, and the next lecture I'll try to address that area before we start with that. So this will be there only when we start with the regular online teaching from 1st of June itself, because so long this part is concerned, it is just a preliminary discussion with regard to various aspects relating to preparation for judicial competitions. Your marks in the LLB are also relevant. That is the last step toward this selection. That is interview. The marks you score in your LLB examination are also relevant for interview also. So, those students who are already still preparing for the law papers, they must thoroughly prepare their papers so that they get good marks in the law papers, which will be ultimately helping them in their interview also. That part we'll discuss as and when that situation comes. So here I would not like to talk about the interview aspect in that case. This is something basic which I wanted to talk to you when you want to go for competitive examination. One more thing before I stop. Take previous year papers. Prepare a chart of all the papers separately. Tick out the areas from which questions are put. If you prepare a chart for 4 or 5 papers, 4 or 5 years, you will be able to know which area normally questions are there. Like so for IPC is concerned, normally questions are there from a right of private defense. Normally questions are there from section 299 and 300. Normally questions are there from section 34. Normally questions are there from attempt. That will give you the information which area is more important. Prepare that area thoroughly. Secondly, that will also indicate those areas out of which a question has never been asked. You can afford to ignore that area because that question has never been put. So in that case, this will provide you both the areas which are important, from which normally the questions are there, areas which are not important, normally from which the questions are not there. One more thing in that aspect is that sometimes some important case comes. That case may not be relating to that important area. That may be relating to an area from which never a question has been put. In view of that case law, it becomes important if something new has been settled, something new has been said in relation to that section, in relation to that offence, in relation to that defence. I just give an example. So far judicial papers are concerned, no question has ever been put from section 377 on natural defense. In 2010, in the Nas Foundation, the Delhi High Court gave the judgment, declaring it partly unconstitutional. And in 2010 paper, the question was there related to that. Thus it became important. So this part, that if some latest judgment is there in relation to any area which otherwise is not considered to be important, that becomes important, and you are to thoroughly prepare that area also. This is with regard to certain things which are preliminary and are necessary for any competitive examination. One more point which I have found, that when you go to the examination center, go with a very clear mind, must malanga wale attitude ਨਾਲ exam ਦੇਣ ਲਓ. Don't unnecessarily think कि यह question ਦਾ ਕੀ answer है, question ਦਾ ਕੀ answer है. You will be confusing yourself. Go with a complete free mind, as if you are going for a picnic. The mind of a human being is very sharp. When you study material, sometimes you feel that you are unable to recollect that, you are unable to answer that. That is not there. The mind of a human being works under pressure. More the pressure, more it will try to reveal and that help you in giving the answer. I just give a very simple example. Just few days before the examination, you start understanding the question more clearly in comparison to what you have done it month back. Why? Because now your mind is under pressure. So don't think that what you have studied will not come to your mind when you will answer there in the question paper. Once that pressure is there, the mind will reveal that and you will be able to answer. But one thing is there, do not confuse yourself before that when you are sitting there. When you are going to the examination center, go with a free mind, go with an open mind. You will be able to answer all the questions in that case. So, once you start thinking over that while going to the examination center or while sitting there, you get confused and sometimes it blocks the mind and you are unable to answer. So avoid that confusion. Sit just like a mast malang. Mind will tell you everything while you will be answering that. Now this is all so far today's lecture is concerned, because I don't want to start with the first lecture itself today. One thing I advise to all the students, that first few lectures, maybe 4, maybe 5, will cover almost 40% of the Indian Penal Code. That will be the foundation of understanding not only the Penal Code but also criminal law. That will help you not only for appearing in the competitive examination, that will help you in profession also. So clarity, conceptual clarity, which you will be receiving, will help you in profession also later on. Competition is hard. You have to be very punctual, make a time frame, at least, because I think before December, January, there is no possibility of any next competition of judicial papers, either of Punjab or of Haryana. So you have around 6-7 months complete, maybe more than that. And that is sufficient to prepare for these papers. Since if you look at the previous year papers, about 80 marks relate to relate to IPC. Same number to CRPC. Evidence normally 50-60 marks. That way IPC is a very important part of that. And it is also scoring. You can score as much marks from the IPC area as you think. So thoroughly prepare this area. One more before we close again is that when you are studying IPC provisions, sometimes you find that some CRPC provisions are also relating to that question, that offence. Or some evidence material is also relating to that offence. When you answer to that question, try to refer to those provisions of IPC, CRPC or evidence just in brief, 1 or 2 lines at the ending part of that. You have to just indicate that I am aware of that this question is relating to some provisions of CRPC or evidence. Like in case of evidence, some sections are there which are related to presumptions. Now these presumptions are related to some of the questions, offences in the IPC. Similarly, some provision in CRPC, especially section 95, 195, 196, 197, 198, 199. All these sections are relating to some specific offences. At the ending part of that answer to the question, make 1 or 2 lines reference to that CRPC or evidence provision also. You are not to elaborate that, you are not to give details of that, you are to just make a small reference to that so that indication is that you are aware of various aspects of that offence. That has to be taken care of by answering to that. Like just an example, for criminal conspiracy, section 96 is there, which is a reference to that. Similarly, some offences related to bigamy, adultery, specific section 198 is there, 199 relates to defamation, CRPC.